The United States House of Representatives has just passed three groundbreaking immigration reform bills in February 2026 that will fundamentally reshape how immigration works in America. After months of intense negotiation and political maneuvering, these bills moved through the House this week with bipartisan support, shocking political observers who expected continued gridlock on one of Washington's most divisive issues. The changes these bills bring will affect millions of immigrants, visa holders, green card applicants, and undocumented individuals currently living in the United States. Texas, as the state with the longest border and the second largest immigrant population in the nation, will experience these impacts more dramatically than almost anywhere else in the country. Whether you are waiting for a visa approval, applying for a green card, seeking asylum, working on a temporary visa, or living undocumented and worried about your future, what just happened in Washington will directly determine your path forward. The next 6 months will be critical for every immigrant in America. Welcome back. This channel exists to deliver facts without political bias, to explain complicated legislation in plain language, and to give you actionable information that helps you protect your status and achieve your immigration goals. If you are new here, please subscribe and activate that notification bell because immigration policy is shifting rapidly in 2026, and being informed in real time could literally save your case or change your life. Today, we are analyzing the three immigration bills that just passed the House of Representatives. We will break down exactly what each bill contains, who will be affected, what happens next as these bills move to the Senate, and most critically, what actions you should take right now to prepare for these changes. This is the most significant immigration legislation to pass the House since the comprehensive reform attempts of 2013, and every single detail matters. Bill 1, the Secure Border and Interior Enforcement Act of 2026. The first bill that cleared the House focuses heavily on border security, infrastructure, enforcement expansion, and consequences for illegal entry. It authorizes $32 billion over 4 years, broken down as follows: $12 billion for wall construction and barrier reinforcement across Texas, Arizona, New Mexico, and California. $8 billion for surveillance technology, including towers, drones, and sensor systems. And $12 billion for hiring and training new enforcement personnel. The personnel expansion alone is staggering. The bill mandates hiring 15,000 new Border Patrol agents over the next 3 years, plus 8,000 new ICE officers. Training academies will be established in Texas, specifically in the El Paso and Rio Grande Valley regions. For communities throughout Texas, this means a substantial federal law enforcement presence, not just at the border, but throughout the interior of the state as ICE operations expand into neighborhoods, workplaces, and communities. One of the most significant and controversial changes in this bill is the elimination of humanitarian parole for most asylum seekers at the southern border. Currently, many migrants who present themselves at ports of entry and claim asylum are paroled into the United States while their cases are processed. This bill ends that practice entirely. Instead, asylum seekers will be held in newly constructed processing centers located on the Mexican side of the border or in third countries that have signed agreements with the United States. Only after initial asylum interviews demonstrate credible fear will applicants be allowed to enter. The bill allocates $5 billion for constructing and operating these offshore processing centers. Supporters say this restores order to an overwhelmed system. Critics argue it violates international refugee law and places vulnerable people in serious danger. For people already in removal proceedings, the bill creates expedited immigration court dockets, requiring cases to be completed within 6 months for detained individuals and 12 months for non-detained individuals. Additional immigration judges will be hired to meet these deadlines. While faster processing sounds like progress, immigration advocates warn that compressed timelines make it nearly impossible for applicants to gather evidence, find attorneys, and build strong cases. Perhaps most alarming for long-term legal residents is the bill's dramatic expansion of deportable offenses. Previously, only aggravated felonies and crimes of moral turpitude triggered mandatory removal. This bill adds a new category called crimes affecting public safety, which includes DUI convictions, domestic violence misdemeanors, certain drug possession offenses, and even repeat traffic violations. Even lawful permanent residents, green card holders, can be placed into removal proceedings for these offenses. If you or someone you know is a green card holder with any prior criminal history, consulting an immigration attorney immediately is not optional. It is urgent. Bill 2, the Legal Immigration Reform and Backlog Reduction Act of 2026. The second bill takes a dramatically different approach. Rather than focusing on enforcement, it modernizes the legal immigration system, reduces catastrophic backlogs, and creates new pathways for skilled workers and families. The centerpiece is the elimination of per-country caps for employment-based green cards. Currently, no more than 7% of employment-based green cards can go to nationals of any single country in a given year. This has created devastating backlogs for applicants from India and China, where highly skilled workers wait literally decades for green cards. This bill eliminates those caps entirely, allowing green cards to be issued based on priority date regardless of country of birth. The bill also increases the overall annual cap on employment-based green cards from 140,000 to 250,000, with automatic increases triggered if demand exceeds supply. For family-based immigration, annual caps rise from 226,000 to 350,000. A new fast-track category is created for parents of adult U.S. citizens, promising processing within 12 months for those who meet financial and health requirements. However, the bill eliminates the sibling sponsorship category entirely. U.S. citizens will no longer be able to petition for brothers and sisters. Current applicants will be grandfathered in and may continue, but no new sibling petitions will be accepted after the bill is signed into law. The visas freed up are redistributed to employment-based and other family categories. A major innovation in this bill is the creation of a brand new startup entrepreneur visa. Foreign nationals who can demonstrate they have founded or will found a business that creates American jobs and generates revenue can obtain a special visa with work authorization and a direct path to a green card within 3 years, if they meet job creation and revenue targets. This visa is designed to attract immigrant entrepreneurs and compete with other countries that have similar programs. Texas stands to benefit enormously. Companies in Austin, Dallas, Houston, and San Antonio that struggle to hire and retain foreign talent will have more options. Workers trapped in decade-long backlogs will finally see movement. That said, Filipino, Mexican, and other immigrant communities that relied heavily on sibling sponsorship will feel the loss of that pathway deeply. Bill 3, the Earned Pathway to Legal Status Act of 2026. The third bill is the most politically contentious, and the one that will generate the most questions from your community. It creates a conditional pathway to legal status for certain undocumented immigrants currently living in the United States. This is not amnesty. It is not immediate citizenship. It is a long, structured process with strict requirements. To be eligible, you must have continuously resided in the United States since January 1st, 2020. You must have no felony convictions and no more than 2 misdemeanor convictions. You must demonstrate continuous employment, enrollment in education, or status as a primary caregiver for a dependent. You must pass background checks and biometric screening and demonstrate basic English language ability and U.S. civics knowledge. Those who qualify can apply for conditional resident status, a temporary legal status valid for 8 years. During those 8 years, you must maintain employment or education, pay all taxes, commit no crimes, and check in annually with immigration authorities. After 8 years of meeting every requirement without interruption, you may apply to adjust to lawful permanent residency, a green card. After obtaining your green card, you must wait an additional 5 years before applying for citizenship through the standard naturalization process. That means the total timeline from undocumented status to citizenship under this program is at least 13 years. Dreamers, individuals brought to the United States as children before their 16th birthday, who have lived here for at least 10 years and graduated from a U.S. high school or obtained a GED, qualify for expedited processing. Dreamers can adjust to permanent residency after just 5 years in conditional status, cutting the path to citizenship down to 10 years total. The documentation burden is real. Acceptable evidence of continuous residence includes rental agreements, utility bills, bank statements, employment records, pay stubs, tax filings, school records, medical records, and sworn affidavits from U.S. citizens or permanent residents who can verify your presence. For many people who paid rent in cash, moved frequently, or worked informally, building this evidence file will take months of serious, deliberate effort. The fees are also significant. $2,000 per adult and $1,000 per child for the initial conditional status application, plus $2,500 per person to adjust to permanent residency, plus eventual naturalization fees. A family of 4 could spend more than $15,000 in government fees alone over the 13-year process, not counting attorney fees or document translation costs. Throughout the entire conditional period, applicants are explicitly prohibited from receiving federal public benefits, including Medicaid except for emergency services, SNAP food assistance, federal housing assistance, and ACA subsidies. You can work legally and pay taxes, but you cannot access the social safety net even during times of hardship. Only after adjusting to lawful permanent resident status do these programs become available. Texas has an estimated 1.7 million undocumented immigrants. If this bill becomes law, potentially 800,000 to 1 million could qualify based on the January 2020 residency requirement. Major metropolitan areas like Houston, Dallas, Fort Worth, Austin, and San Antonio have large undocumented populations who have built deep roots, raised families, and established lives over many years. This bill offers a chance at legal status, but the path is long, expensive, and filled with requirements that will exclude many. What happens next? It is absolutely essential to understand that these three bills have only passed the House of Representatives. They now move to the Senate, where the political landscape is very different. Several scenarios are possible. The bills pass the Senate largely unchanged. They are significantly amended through negotiation. They are combined into a larger legislative package, or they fail entirely if they cannot overcome the 60-vote threshold needed to break a filibuster. Even if the bills pass the Senate, they must be signed by the president to become law. And even after signing, implementation will not happen overnight. Federal agencies must write regulations, build systems, train staff, and establish procedures. The Conditional Resident Status Program would likely take 8 to 12 months after enactment before applications can even be accepted. What you should do right now. If you are undocumented and potentially eligible, start gathering documentation immediately. Do not wait for the bill to become law. Collect every piece of evidence proving your presence in the United States since January 2020. Rent receipts, utility bills, bank statements, tax records, employment letters, medical records, church records, anything with your name and a date. Organize everything chronologically and store it safely. If the bill becomes law, you want to be among the first to apply. If you have been paying taxes using an ITIN, make absolutely certain you file your 2024 and 2025 tax returns on time. Tax returns are among the strongest evidence of presence and good moral character. If you have not been filing, consult with an immigration knowledgeable tax professional and start now. If you are a green card holder with any prior criminal record, consult an immigration attorney immediately. The expanded deportation grounds in Bill 1 create new risks that did not exist before. If you are a U.S. citizen planning to sponsor a sibling, file the I-130 petition right now. The grandfather clause in Bill 2 protects petitions already filed before enactment. Filing today preserves your sibling's place in line, even if the category is later eliminated. If you are stuck in the employment-based backlog from India or China, monitor this legislation closely. The elimination of per-country caps could dramatically accelerate your timeline. But do not make irreversible life decisions based on pending legislation. Maintain your current status and continue your existing applications. And above all, be vigilant about immigration fraud. Whenever major legislation is pending, scammers multiply. They charge fees for programs that do not yet exist and prey on people who are desperate for legal status. Only work with licensed immigration attorneys or DOJ-accredited representatives. Never pay cash without a receipt. Never sign blank forms. Never let anyone keep your original documents. The passage of these three bills through the House represents a historic moment. For the first time in over a decade, comprehensive immigration legislation addressing enforcement, legal immigration, and undocumented populations has moved forward with genuine bipartisan support. Whether these bills ultimately become law remains uncertain. But the fact that they passed the House proves that political will for immigration reform exists, even in a divided government. For immigrants throughout Texas and across the United States, these bills represent hope, anxiety, opportunity, and risk, all at once. The enforcement provisions create new dangers and expand grounds for deportation. The legal immigration reforms offer real relief to hundreds of thousands stuck in backlogs and create new opportunities for skilled workers. The earned legalization pathway provides a chance for millions to emerge from the shadows, though the requirements are steep and the road is long. This channel will monitor every step of the way. We will track the Senate debate, analyze every amendment, report on final passage or failure, and provide you with detailed, practical guidance on how to navigate these changes if they become law. Immigration law is complicated, the political process is unpredictable, and reliable information is hard to find. That is exactly why this channel exists, to give you the facts, the analysis, and the practical advice you need. If this video helped you understand what just happened in Washington and what it could mean for your future, Please hit that thumbs up button and share it with family, friends, and anyone in your community who needs this information. Subscribe and turn on notifications so you receive instant alerts as this situation continues to develop in the Senate and beyond. Drop a comment below telling us how these bills would affect you personally. Are you eligible for the earned pathway? Are you waiting in an employment backlog? Are you worried about enforcement? What questions do you have? Your engagement helps us create content that addresses your real concerns. Your future matters. Your family matters. Your American dream matters. Stay informed, stay prepared, and never stop fighting for your place in this country. We are here with you every step of the way.